Good evening. Tonight I want to talk to you about a case that has shocked not just Hollywood, but the entire nation. A case that forces us to confront uncomfortable truths about family, mental health, and the justice system itself. I'm referring to the tragedy involving Nick Reiner, currently held without bail, accused of the unthinkable murders of his parents, the legendary filmmaker Rob Reiner and his wife Michelle Singer Reiner. The news that broke recently concerns the arrest of foreign nationals in South Africa, specifically Kenyans who have been accused of illegally processing applications under what has become known as a contentious refugee scheme targeting white South Africans. This program, initiated under the Trump administration in the United States, has created a complex web of legal, diplomatic, and ethical questions that we need to carefully unpack over the next 2 hours. Let me begin by establishing the context. The United States, under the previous Trump administration, established a program that specifically addressed what some groups have characterized as persecution of white farmers and Afrikaner communities in South Africa. This program offered a pathway for white South Africans to seek refugee status in the United States, claiming they faced systematic discrimination and violence in their home country. The South African government vehemently rejected these characterizations, viewing them as both historically tone-deaf and factually inaccurate, particularly given South Africa's complex post-apartheid journey toward reconciliation and equality. Now, what we're seeing is the arrest of Kenyan nationals who were allegedly operating within South Africa to facilitate these applications. According to the reports from Reuters, these individuals were processing applications illegally, which raises immediate questions about the nature of their operation, who was involved, how extensive this network was, and what motivated their involvement in this particular scheme. Let me break down the immediate facts as we understand them. South African authorities have detained these foreign nationals and have announced their intention to deport them back to Kenya. This action represents a firm stance by the South African government against what they perceive as interference in their internal affairs and a violation of their immigration laws. The deportation process itself will likely take several weeks to months, depending on legal challenges, diplomatic negotiations, and the specific circumstances of each individual case. The first major outcome we need to consider is the diplomatic fallout between South Africa and Kenya. These are two of Africa's most important economies and regional powers. Kenya has historically maintained strong ties with South Africa, both economically and politically. The discovery that Kenyan nationals were involved in what South Africa views as an undermining of its sovereignty could strain these relations significantly. We should expect to see high-level diplomatic communications between Nairobi and Pretoria in the coming weeks. The Kenyan government will need to decide whether to defend its nationals, claiming they were engaged in legitimate business activities, or to distance itself from their actions, potentially arguing that these were rogue operators acting without government knowledge or sanction. From Kenya's perspective, there are several possible responses. The government could cooperate fully with South African authorities, accepting the deportees and potentially prosecuting them under Kenyan law if they violated any domestic statutes. Alternatively, Kenya could push back, arguing that South Africa is overreaching and that the arrested individuals were engaged in legal consulting or advisory services that happen to be politically sensitive but not actually criminal. A third scenario involves Kenya requesting more information and conducting its own investigation before taking a clear position. Each of these approaches carries different risks and benefits for Kenya's international standing and its relationship with South Africa. Now, let's examine the South African government's position more deeply. The decision to arrest and deport these individuals sends multiple messages simultaneously. First, it demonstrates South Africa's determination to control the narrative about conditions within its borders. The South African government, led by the African National Congress, has consistently rejected claims that white South Africans face systematic persecution. They acknowledge that farm attacks are a serious problem affecting all South Africans in rural areas, regardless of race, but they strongly dispute the characterization of these incidents as racially motivated genocide or ethnic cleansing. By cracking down on those facilitating refugee applications based on these premises, South Africa is asserting its authority to define its own internal situation. Second, this action represents pushback against what South Africa views as neo-colonial interference. The Trump administration's refugee program was seen by many in South Africa as an attempt to relitigate apartheid-era racial politics on the international stage. For a country that has spent 3 decades building a constitutional democracy based on racial equality and reconciliation, the The suggestion that white citizens need protection from the very government that has guaranteed their constitutional rights is deeply offensive and politically charged. The arrest of these facilitators is, in some sense, South Africa saying it will not tolerate foreign actors undermining its post-apartheid project. Third, there's a legal dimension that we cannot overlook. If these Kenyan nationals were indeed operating illegally, processing immigration applications without proper authorization, then South Africa has every right under international law to enforce its immigration statutes. No country is obligated to tolerate foreign nationals conducting unauthorized immigration services within its borders, particularly when those services involve applications to third countries based on claims the host country disputes. Let's turn our attention now to the United States' role in this situation. The Trump administration's refugee program for white South Africans was controversial from its inception. Critics argued that it was based on exaggerated or false claims about widespread anti-white violence in South Africa, that it played into white nationalist narratives popular among some segments of Trump's political base, and that it represented a selective approach to refugee admissions that privileged white applicants from a country with a history of white supremacist government. Supporters of the program argued that farm attacks in South Africa were indeed targeting white farmers disproportionately, that the South African government was not adequately addressing the violence, and that the United States had a moral obligation to offer refuge to those facing persecution regardless of their race. With the change in administration in the United States, this program's status has become uncertain. The Biden administration has taken a different approach to immigration and refugee policy generally, and there's been less emphasis on this particular program. However, the machinery established under the previous administration continues to exist, and applications that were already in process have continued to be evaluated. The discovery that illegal facilitators were operating in South Africa to feed applications into this system creates a problem for the United States as well. American immigration authorities will need to review any applications that may have been processed through these illegal channels to determine their validity. We should anticipate that the U.S. State Department will need to address this situation diplomatically with both South Africa and Kenya. The United States will want to maintain its relationships with both countries, which are important partners in Africa. At the same time, the U.S. has legitimate interests in ensuring the integrity of its refugee and immigration processes. Applications processed through illegal means compromise the system's credibility and potentially allow fraudulent claims to be advanced. The potential impact on the individuals who have already received refugee status or whose applications are pending is significant. Those who use the services of these arrested facilitators may find their applications frozen or subjected to additional scrutiny. In some cases, refugee status that has already been granted could be reviewed or even revoked if it's determined that the application was based on fraudulent documentation or false claims. This creates tremendous uncertainty for families who may have already relocated to the United States or who were in the process of preparing to do so. Let me address the broader implications for refugee policy and international law. This case highlights the tension between a country's right to define conditions within its borders and the international community's interest in protecting genuine refugees. The 1951 Refugee Convention and its 1967 Protocol establish that refugees are people who have a well-founded fear of persecution based on race, religion, nationality, membership in a particular social group, or political opinion. The determination of whether someone qualifies as a refugee is complex and involves both subjective fears and objective conditions in their home country. What makes the South African situation particularly complicated is the historical context. South Africa's apartheid past creates sensitivities around any claims of racial persecution, particularly when those claims come from members of the formerly privileged white minority. At the same time, the principle of refugee protection should apply equally to everyone who meets the criteria, regardless of their race or their country's history. Threading this needle requires careful, fact-based analysis rather than ideological positioning. From a legal standpoint, the operation of these Kenyan facilitators raises questions about the growing industry of immigration consulting and its regulation. Around the world, there are legitimate immigration consultants and lawyers who help people navigate complex immigration systems. There are also unscrupulous operators who prey on desperate people, charging exorbitant fees for services of dubious legality or effectiveness. If the arrested Kenyans were operating without proper licensing or accreditation, they may have been engaged in immigration fraud, even if some of their clients had genuine claims. This distinction matters because it separates the criminality of the facilitators from the potential legitimacy of some of the underlying applications. Now, Let's consider the economic dimensions of this situation. Immigration consulting has become a significant business globally, with billions of dollars flowing through this industry annually. The promise of resettlement in wealthy countries like the United States creates powerful economic incentives for people to pay for assistance with their applications. In countries with high unemployment or limited economic opportunities, operating as an immigration facilitator can be lucrative. The fact that Kenyans were involved in processing applications for South Africans to move to the United States illustrates how internationalized and commercialized these processes have become. The deportation of these Kenyan nationals will likely disrupt networks that may extend beyond just these individuals. South African and Kenyan authorities should be investigating whether there was a larger organizational structure behind this operation. Were these independent operators or part of a coordinated network? Were there South African citizens involved in facilitating this process? Were American immigration lawyers or consultants part of this chain? The answers to these questions will determine how widespread the problem is and what additional enforcement actions might be necessary. Let me turn now to the political implications within South Africa itself. The issue of farm attacks and rural safety is genuinely contentious in South African politics. Opposition parties have criticized the ANC government for not doing enough to address rural crime. Some groups have indeed called for international attention to what they characterize as a crisis. The ANC government, meanwhile, has pointed to crime statistics showing that farm attacks, while serious, are not evidence of systematic racial persecution but rather part of South Africa's broader challenges with violent crime affecting all communities. This internal political debate becomes internationalized when foreign governments like the United States create special programs that implicitly validate one side's narrative. The arrest of these facilitators allows the South African government to demonstrate that it takes seriously any foreign interference in its internal affairs. It also allows the government to reinforce its message that claims of anti-white persecution are exaggerated and that foreign actors who promote these narratives are acting in bad faith. Opposition groups may counter that the government is more concerned with controlling the narrative than with addressing the underlying security concerns that drive some South Africans to seek refuge elsewhere. From Kenya's domestic political perspective, this incident is likely to generate relatively little controversy. Kenya has its own complex immigration challenges, including hosting large refugee populations from neighboring countries experiencing conflict. The revelation that some Kenyans were operating in South Africa to facilitate applications to the United States is unlikely to trigger major political debates within Kenya, though it may lead to questions about what oversight exists for Kenyan citizens engaged in international consulting or advisory services. Let's discuss the timeline for how this situation will likely unfold over the coming weeks and months. In the immediate term, we should expect the arrested individuals to have access to legal representation and potentially to contest their deportation through South Africa's legal system. This could delay the deportation process significantly. South African immigration law, like that of most democracies, provides due process rights to foreign nationals facing deportation. These individuals can argue that they weren't actually engaging in illegal activities, that they face persecution or hardship if returned to Kenya, or that there were procedural irregularities in their arrest. Simultaneously, diplomatic communications between Kenya and South Africa will intensify. We may see statements from both governments clarifying their positions. Kenya will need to decide whether to request consular access to the detained individuals, which is standard practice under international law. South Africa will want to ensure that it's following proper diplomatic protocols even as it enforces its immigration laws. In the United States, the Department of Homeland Security and the State Department will need to review their processes for accepting and evaluating applications under this refugee program. They may pause processing applications from South Africa temporarily while they investigate the extent of potential fraud or illegal facilitation. This review could take months and will create anxiety among legitimate applicants who have done nothing wrong but who are caught up in the fallout from this enforcement action. Over the medium term, spanning perhaps 6 months to a year, we should expect to see policy adjustments. South Africa may strengthen its enforcement against unauthorized immigration consultants. Kenya might implement new regulations for citizens engaged in international consulting or advisory services. The United States could modify or terminate the Trump-era refugee program for white South Africans, or it could add additional screening and verification requirements. Looking further ahead, this incident may influence the broader international conversation about refugee determination and the role of race in asylum claims. Human rights organizations will be watching closely to ensure that legitimate refugees aren't denied protection because of the actions of illegal facilitators. At the same time, advocates for more restrictive immigration policies may use this case as evidence that refugee systems are susceptible to fraud and abuse. Let me address some of the ethical dimensions that make this case so complex. On one hand, we have the principle that people fleeing genuine persecution deserve protection, regardless of their race or nationality. On the other hand, we have the reality that not all claims of persecution are accurate, and that allowing false or exaggerated claims to succeed undermines the integrity of refugee protection systems. The presence of illegal facilitators complicates this picture further because their involvement doesn't necessarily mean their clients' claims were false, but it does raise questions about the validity of the application process. There's also the question of equity in refugee protection. Critics of the Trump program argued that it was unfair to create special pathways for white South Africans while refugees from other African countries facing far more severe violence and persecution faced much higher barriers to resettlement. This raises uncomfortable questions about which lives and which forms of suffering receive international attention and assistance. A truly just refugee system would evaluate all claims on their merits rather than creating programs that seem designed to favor particular racial or ethnic groups. From the perspective of ordinary South Africans, both white and black, this controversy is likely frustrating. Many white South Africans feel genuinely unsafe, whether or not their fears are statistically justified, and they may resent their government's dismissal of their concerns. Many black South Africans feel that international attention to the relatively small number of farm attacks represents a continuation of the historical pattern where white suffering receives more attention than black suffering, even in a country where poverty and violence disproportionately affect black communities. Both perspectives contain elements of truth, and both deserve to be heard in a mature democracy. As we move toward the conclusion of our discussion, let me highlight several key points that we should all keep in mind as this situation develops. First, this is fundamentally a story about the intersection of national sovereignty, immigration law, and international politics. South Africa is exercising its right to enforce its laws within its territory. Kenya and the United States are both affected parties with their own interests to protect. How these three countries navigate their competing interests will test the strength of their diplomatic relationships. Second, this case illustrates how immigration and refugee issues have become increasingly commercialized and internationalized. The involvement of Kenyan facilitators in a program designed for South Africans to move to the United States shows how complex and multi-layered modern migration has become. This complexity creates opportunities for both legitimate service providers and criminal operators. Third, the underlying questions about conditions in South Africa and whether white citizens face persecution remain contentious and unresolved. This is not a simple matter of fact but involves interpretation of statistics, understanding of context, and political judgment. Reasonable people can disagree about whether the situation justifies special refugee programs, and this disagreement is likely to continue regardless of how the current enforcement action plays out. Fourth, the impact on individual applicants and their families should not be forgotten in the larger diplomatic and political maneuvering. Real people have made life-changing decisions based on their belief that they qualify for refugee protection. Learning that the process they used was compromised by illegal facilitators will be devastating for many of them, whether or not their underlying claims had merit. In conclusion, the deportation of Kenyans involved in this refugee scheme represents a significant moment in the ongoing evolution of immigration policy, international relations in Africa, and the global conversation about refugee protection. Over the coming months, we will see how South Africa, Kenya, and the United States each respond to the challenges this situation presents. We will learn more about the extent of the illegal facilitation network and whether additional enforcement actions are warranted. We will see whether diplomatic relations between these countries are damaged or whether they manage to navigate this controversy without lasting harm to their partnerships. What remains certain is that immigration and refugee issues will continue to be among the most politically charged and ethically complex challenges facing the international community. Cases like this one remind us that there are no easy answers, that multiple legitimate interests often conflict, and that the search for just and workable solutions requires careful thought, good faith on all sides, and a commitment to both protecting the vulnerable and maintaining the integrity of legal systems. Thank you for your attention over these 2 hours. I hope this analysis has provided you with a deeper understanding of this developing situation and the many factors at play. As more information becomes available in the coming weeks and months, I encourage you to follow this story and to think critically about the competing claims and interests involved. The way we address questions of migration, refuge, and international cooperation will shape our world for decades to come, and cases like this one are where theory meets reality. Thank you.